James, I love the t-shirt, mate.
Thank you very much.
Nice, bold start to the day.
Yeah.
Rolling Stone.
There's no moss.
Gathers no moss. How are the family and the boys and everything? All right? Good?
Yeah, very well, thanks. They're homeschooling, it's supposed to be. But as you know, it's pretty difficult to police when I'm trying to work full-time here. So, yeah.
Yeah. Have you had the email yet from school saying so-and-so hasn't logged on for their lesson?
Yes, we have, unfortunately. Yeah.
We've had a few of those most days.
Yeah.
So, yeah. Oops. Sorry about that. Okay. Well, welcome to the church office, and it's a joy to be able to interview James Moss this morning. And one of the questions that keeps coming up from the emails that we're receiving from churches and folks is questions about employment law and about HR and about those things that happen behind the scenes as people start to employ people in their churches. So we've sought a specialist, a top man, James Moss from Slate Legal. So mate, thank you for joining us and giving up your time today to be able to do this and answer some questions. James,
Gavin.
Tell us a little bit about yourself, my friend, and how you got into this employment law specialist that you are.
Well, so it's a long story. But well, I suppose in terms of my my job, what I do, I've been practicing now for over 20 years. I qualified back in 2000. My journey to where I am now is I started back in school, back in basic comp, when I was doing my A-levels, economics, history, and French. I really enjoyed. I wanted to combine all three and use them in my job. No one in the family was a lawyer. My parents at the time were teachers. Mum was a special needs teacher. Dad was a lecturer in the School of Nursing, but I really enjoyed those subjects. I wanted to carry on with them. So I went on to study a degree in law at King's College London, and I did a further 2 years in Paris studying for a degree in French law at the Sorbonne. Two great cities, had a great time there. I graduated in 1998, it's a long time ago. I did a training contract with, at the time, one of the world's largest international law firms, Eversheds. Whilst I was there, managed to wangle another 3 months back in their Paris office, which was good fun, doing French labour law, amongst other things. And then I qualified in 2000, joined an leading employment law firm at the time, Capital Law. And a few years later, went to TLT in Bristol. And then I came back to Cardiff to join another firm, Untitled Legal. I was head of employment there, partner there. Several years before I decided to leave and launch my own specialist employment practice, Slate Legal. So that was 2016 we started Slate Legal, and really enjoyed it. I mean, over the past 20 years, as you probably imagine, I've advised a wide variety of employees from all walks of life, and all employers of all sizes as well, the private sector, public sector, third sector, including churches. On the full range of employment issues, non-contentious stuff, which is the kind of issues that crop up on a daily basis, like performance issues, disciplinaries, grievances, contractual issues, whistleblowing, redundancies, etc. And then also contentious stuff. So that means litigation, really. So defending, bringing tribunal claims, employment tribunal claims like unfair, wrongful dismissal, discrimination, unlawful deduction for wages, etc., etc. So I enjoy it. It's a good mix of contract law and tort law. If you're a lawyer, you know what I mean. But I find it interesting. It's no case is the same. All the queries I get on a daily basis are very varied. So that's what keeps it interesting and fresh for me.
Great. I love the fact that you spent some time in France, mate. That must be one of your passions as well.
Oui.
So it's funny. We've had a few church from France log on to the church office. So maybe this might be relevant for them as well. So you're a French speaker as well?
Yes, I had to be fluent in French to get on the course. So my interview when I went to King's years ago, the interview was part in English, part in French, with a French professor. So I really got on well with French in basic comp and just really enjoyed it. That started from family holidays in south of France with my parents. So that's where it all came from. And in fact, the time out in France, it really was what I loved the French language, but I wanted to do something rather than just French. French law would be more useful for me, so I did. And actually, it has been quite useful. And the comparison between, it's very different. There are some similarities, and it's also good to know different ways of thinking, different ways of legal reasoning. And surprisingly, though I'm based in Newport, I have had a number of issues in French where I'm able to advise, for example, a French client or a UK subsidiary based out in France on British employment law.
Okay.
So that was good.
Yeah, that's interesting.
Yeah, so it does happen.
Yeah, it does happen, and it comes across the world. I love that. And so we're talking today about how churches should operate in the background, as it comes to contracts, as policies that they need in place. And if I'm honest, lots of churches don't have a lot of this stuff in place, or it's very archaic. They haven't updated it for many, many years. So what would you say are absolute essentials for churches to have in place as they start to begin to employ staff, a pastor, youth worker, kids ministry, or administrator? Lots of those kind of roles happen. And mate, what would your perspective be on that?
Well, yeah, I'd say there's a number of policies, employment policies, which are essential, and other policies which are nice to have, but not necessarily essential. So I think the essential ones, I would say, for all employers, including churches, regardless really of the number of employees, is about, I'd say 9, I think. So the reason I'd say they're essential is because they're either required by law, or without them, the employer will be deprived of a potential defence, or they'd be on a back foot when defending claims that arise due to the conduct of their staff. For example, discrimination claims, unfair dismissal, health and safety breaches, bribery, that sort of thing. So the 9 essential policies and procedures, I'd say, were firstly, equal opportunities policy, an anti-harassment and bullying policy, disciplinary procedure and rules, grievance procedure, health and safety policy, anti-corruption, bribery policy, data protection policy, and data retention policy. I'd say that those are the 9 essential ones. And basically, it's really prudent for churches in particular to take prompt action to put those policies in place, because they'll protect them going forward. And most employers will put them into a staff handbook and make it available to their staff on an intranet or internal shared drive, and draw the attention of new recruits when they join during the induction process. So that's very important. And similarly, on a similar level, it's important to have decent employment contract templates in place as well, covering all the key terms, and ensure that they're provided to new starters on, or ideally well before the first day of work. It used to be that you could provide that within 2 months of the person starting, but the laws changed. Now the contracts have to be in place from day one. So it's good practice to get them to the employees well in advance of that. And the other reason for that, common sense reason, is that the obligations, that the employees' obligations, are known to them, clearly known to them, before they set foot in the office, before they set foot in the place of work. And so they know where they stand, and you know where you stand as an employer, and that protection is in place. What you don't want is for someone to start working for you, and then there to be a dispute as to the terms. It gets all messy. Much better to have it all agreed and all sorted before they start the actual job. So that's the case for contracts. And when providing the employment contract, if you had those 9 essential policies in place, it'd also be appropriate to provide a copy of those to the employee, so they know the sort of policies they'll be working to when they join you.
Yeah, absolutely right. And I think, lots of church administrators that I've met will share contracts between each other, or they'll get online and Google employment contracts and will download a £5 contract or something as a template, and that will be the starting basis of it. And I think there are probably few that do take legal advice, James. I'm sure you'd say that's a big, massive no-no.
Yeah, well, it's important to have the right policies in place. It's no good having ones that are, inappropriate for your organisation, because it won't help you when it comes to claims being made, or that sort of thing. So it's important to have them really tailor-made to your organisation.
Yeah, and you never think it's going to happen to you, do you? You never think, you're in a church situation, you think, right, we all love Jesus, we love the gospel, no one's there's going to be no conflict here, no issues, and you can be, it's foolish thinking to think that way, isn't it?
Well, it's wishful thinking. It's reality is you don't know what will happen from day to day, so you need to protect yourself by having in place, entirely reasonable policies and procedures, which are really common sense, but set out in writing, so there can be no debate as to what you really thought, so what their obligations are, and what your obligations are as an employer.
Yeah, and I think organizationally in churches, you tend to have trustees and deacons who may be working those kind of background stuff that aren't always necessarily involved in the running of the organization day to day. It is the pastors who might be hiring people and are working through them. And few churches that I know have got, HR experience in them. I mean, some have been blessed. I know there's a couple of churches who do have, people who've worked in those kind of industries before that can give a bit of advice. So if you were to talk to pastors here, and they might be listening into this podcast or watching this video, what advice would you give a pastor who may have ignored comments previously from trustees or deacons? How do we bring people to work together in this to see change and to make sure we're covering the right bases?
Well, I mean, it's important to have these policies in place because from a church perspective, they'll protect you if you are sued. So certain claims, as I said before, the reason why those policies I deem to be essential is because without them, you often don't have the classic defense. So, for example, discrimination matters is what's called the employer's reasonable steps defense, which is that if you put in place proper equal opportunities policy, or might be called equality and diversity policy, and you show that you don't condone any behaviour that would be discriminatory on grounds of sex, race, disability, sexual orientation, religion, belief, age, etc., the protected characteristics. As long as you make that clear, you don't condone that, and it's not tolerated, and action will be taken on disciplinary front. And you can show that you've communicated that policy effectively to your staff and trained them on it if necessary, which will be necessary. And as long as you've done that, you can show that you did everything reasonable, took reasonable steps to prevent that kind of thing happening. If you haven't got a policy in place, you can't really argue that. So you're deprived of that statutory defence. So that's one example. And then again, going back to disciplinary matters, if you haven't got clear disciplinary rules in place in the first place, the employee is going to say, well, I didn't know that was gross misconduct. How was I supposed to know? He didn't tell me. So you need to set it out clearly in writing. And that's why disciplinary rules and the procedure itself need to be very clear. And also the disciplinary procedure would need to comply with what's called the ACAS Code of Practice on disciplinary grievance procedures. And that spells out really common sense things, but it's obviously not that common sense. They have to spell it out for you, but they're there to guide you. And the policy has to make sure it complies with that. As long as it does comply with that, then again, you've brought that to the employee's attention. You're in a much stronger position to defend the action you took based on the misconduct, and so you follow those procedures through. So if you just copy something off the internet, which is not really tailored to you, might even be the wrong country, it's not really going to help you, and you'll be in a tricky situation when problems arise, which they may well arise. Yeah,
absolutely right. Yeah, and it's worth spending the money if you're going to invest into bringing a staff member onto your pastoral team or onto your church office team as a youth worker or various different roles. Then the investment to think about having these policies and paying for some advice is a good investment into that person, into that organization. And what you're saying is it also protects the organization, doesn't it? That if something comes up and there is a disciplinary matter or there is a dispute or something, somebody wants to take legal action against you, the church have done everything that they can to protect the organization.
Exactly.
And ultimately the gospel then, isn't it? Because this could be a major distraction, couldn't it, for a church? For people
absolutely. Very time consuming. Often volunteers involved, give up their own time, and to have to deal with these sort of things will take a lot of time. Obviously, lawyers, if you instruct lawyers, they'll take the strain off you, but still be a lot of running around and investigating and chairing meetings, which is something that the church, their office staff, management team would need to deal with. I mean, it's good practice to get it in place, get the right policies and contracts in place from day one, and it really is recommended. Yeah.
It's
a false economy to think you can get something cheap off the internet, because as I said, it'll come back to bite you.
Yeah, yeah. If something goes wrong, then it can go really, really badly wrong. Then, as a result of those choices. Yeah, and that's absolutely right. And are you happy on the website just to name those policies, those 9 policies, and we can put together maybe a fact sheet for someone to say, please consider these nine policies. And I know in the past you've supported churches in terms of doing an audit on the policy that they've already got in place. So this isn't necessarily buying into a whole package, is it, and having to buy all 9. You may already have some in place that your services can review those and sort of audit those and say, these are great.
Absolutely. I mean, if for example, if the church was wondering, whether their policies are up to scratch, they could, for example, email them across, we check them, and if they're fine, they're fine. If they're not, we might suggest replacing it completely with one of our templates, or alternatively, we can edit what they've currently got and work with that.
And work with them.
One other thing to say, I think, in relation to how often you should review these policies and procedures. There's a case that came out only yesterday by the EAT, which is the Employment Appeal Tribunal in London, and it's quite an interesting case from in relation to our current discussion. Basically, in that case, the tribunal was entitled to reject an employer's reasonable steps defence to a racial harassment claim, and that was because they decided that the policies, the equality and diversity training, which had been given 2 years previously, had become stale and ineffective, and they said that the EAT said it would have been a further reasonable step to give refresher training. So that's a reminder that even if you train your staff on all these policies, you need to keep refreshing it really every so often, and take a view as to whether what's in place is still in date. So in this case, something that was 2 years old was deemed to be stale and ineffective. Maybe the policies themselves weren't very good, but still, you need to bear that in mind. So there will be ongoing training required, I would have said, as well.
Yeah. So it isn't just a tick box exercise that you buy in some policies.
Forever. No, you've got to revisit it and make sure it's updated. Which is, best practice would be just internally as a church, just to review your own policies every year and contracts. See if anything over the years cropped up, which means you might want to tweak a few things here and there, and you can do that yourself potentially. But it's good to keep an eye on these things, and if anything major crops up in the future, then you can get back in touch with your solicitor and discuss it.
Yeah. So James, how much of your clients are you going back to saying, right, the previous template that you've had with us 2 years ago needs to be updated. Here's some changes. Are you providing that kind of service to your clients as well? That as the law changes or as there's things that come into place, you're advising on that?
It's not so much the procedures that policies that change. It's the training. People forget what they learned, because of course something may never arise. You have to put the policy in place. Maybe 3 or 4 years, 5 years go by. No one's brought any claims against you. You've forgotten all the training you had 5 years ago. That's just too late. So this case yesterday was basically saying that it's all great to have the training, but if you don't update the training every now and again, then everyone forgets what they learned, and which is common sense really. So so I would say the policies and procedures that, for example, we would provide will be up to date at the point that we provide them. But the training that goes with that, because personalities change, people leave the church, people join the church, and those new starters need to have the same training. So it'd just be a matter of scheduling in, training every now and again, potentially every 2 years.
And I think one of the questions that we've had from other churches is saying that it's all very well, I need to update my policy, I need to do the training and stuff, but how do I move people that are on older contracts to some of the new contracts? How do you implement some of this in a culture that doesn't spend time doing these practices? James, what advice could you give for that?
Well, it's a good question, because there's a legal procedure for this. You can't just change someone's contract. That would be a breach of contract. You have to consult and agree changes. So there's a process for implementing new contractual terms. So, for example, if you find that your current template contract is rubbish and you need to update it and change it, well, you'd decide on what the change is going to be, what the new contract looks like, and then you consult with the existing staff and say, look, we need to you need to update your contract. It hasn't been updated for ages. The law's changed in the meantime. These are changes we're suggesting we make. These are the reasons why, it's in line with the current law, this is irrelevant, and we've changed it, and explain it to them why you made those changes, the rationale for it. And then hopefully they'll agree to those changes, especially if they're just done to keep the contract in line with the current law. But if they don't agree with it, then there is a procedure called it's called fire and rehire colloquially. But essentially, hopefully it won't come to that. But essentially, if the changes are essential to your business, you really need to make those changes, and the employee is adamant that they refuse to agree to it, it can come to the point where, after consultation and having had full meetings with them, give them an opportunity to raise their objections and for you to respond to that, you can potentially force through your decision to have that new contract. So you'd say, well, unfortunately, then, if you're unwilling to accept the new terms, we're going to have to terminate your contract on notice, or with payment in lieu of notice, if that's a new contract. And then we'll offer to rehire you on this new contract on these terms with immediate effect. They'll probably still say no, and give them a right to appeal. And if that's the end of the line, and so you'd have to recruit someone new. But that is the ultimate sort of end of the line. And the reason for that dismissal will be what's called some other substantial reason, namely their failure to agree to important changes to terms and conditions of employment. So it's not a nice thing to do, but it's there to protect the employer. Otherwise, the employer could never change terms and conditions of employment if the employee refused. So that's the ultimate. In relation to policies and procedures, it's always important that they don't become contractual, so they remain pure policies, which means you can change them as the employer without having to go back to your employees to ask for their consent every time. So I'd never recommend that you tie in the policies and say that in the employment contract that the attached handbook is contractual, or this policy forms part of your contract. It doesn't. It's always important to make it clear that the policies do not form part of your contract, and may be changed by the employer at any time. And obviously, you'd be reasonable as an employer, and if you did change the policy, you bring the change to the employee's attention, and if necessary, give additional training on it. But yeah, that's there to ensure to ensure business can operate really, and organizations can operate effectively.
And excuse me, James. And I mean, as a pastor listening to this or trying to work through that seems like a tough road to go down, doesn't it? Going through the organizational change, and then dealing with all the different aspects of that, and the employee's perspective on how they interpret the contract and whether they're happy to agree or not. And it could lead to a whole host of other pastoral issues, and it's a really different or difficult context in church, isn't it, when you're working together and you're part of a local church and you're trying to pastor someone and you hold both of those roles in tandem. James, is there a way for contracts that you've got in the past with staff not to change, and for you to just, anyone that you new take on, you start implementing slowly new changes? Is that
that's an easier way of doing it? Yes. So if you agreed new contracts, then you just make sure that for all new starters start on the new contract. As long as the pay is the same, the same basis as existing staff. And there are no provisions in there which would be discriminatory, then there'd be no issue, no equal pay issue, for example. That's fine. But that's the easy way of doing it, because you wouldn't need to force everybody else to change their current contracts. Although you might want to consider, if the terms are radically different from the terms that the other staff have, then you might want to try and harmonise them all and go through a consultation process.
And most of the time churches are talking about sort of 2 or 3 people. So, obviously some of the bigger churches may be more, but you're right. You can. There are different ways to implement this, and to be on a bit of a journey to make some changes. Not everyone can go, right, I'm stopping there, I'm going to go this way and go 100% to what you're saying. It is a bit more of a process, isn't it? And hopefully people will begin to start to engage with this, because often I think it's one of those things that they don't talk about and we don't address. and it does lead to burying your head in the sand, and eventually, you are going to get caught out on it, aren't you, somewhere along the line?
Yeah, I think it's highly unlikely that in a church context you have to go down the fire and rehire routes, because you'd hope that the Christian ethos of the place would mean that consultation would naturally lead to resolution and nothing else, and you wouldn't need to force anything through. But that said, there's always exceptions to the rule, and you can never guarantee that the whole thing will go smoothly.
You can't.
But I think it's more likely in a church context than any other context, to be honest.
That's going to be more straightforward. No, that's really helpful, Nate. And so Slate Legal have loads of these templates in place, and I know you and I have been chatting about how could you get behind some of the churches that are following the church office, that are being supported. And I know you've put together some packs and some prices and stuff that people can access through the church office to help them, and you've sort of templated, here's what it would cost to move from one set of contracts and handbook to a new set, and what legal advice you need and what the costs are, and all of those things, and we can make those available to people, and to email, obviously email you directly, James, or to come through the church office at info@thechurchoffice.co.uk, and we can connect you to start that conversation. And I think it's important that even if you've got to start a journey, and you may be in an organization where you're a trustee or a deacon, and what you're hearing today, you think, I need to put some action in place, then start a conversation, and let's talk about. James is available to give some advice and say, right, this is how you need to start going. These are the people you need to start speaking to. And I'm sure there are trustees who ultimately are responsible for a lot of churches, have a responsibility to ensure that the legal aspects of employment law are being met. And that is important. So a refresher for the role for trustees: if you're a trustee, then check you've got these things in place in your organizations that you're supporting in that role. James, give us a couple of scare tactics of people who haven't put some of these things in place, some of your experience where maybe not necessarily churches but organizations where they've been stung by not having this. You're not talking just a few £1,000s here, are you, in claims?
No, I mean for discrimination claims, there is no limit of compensation in theory.
Okay.
The employee, if you get it wrong, they can claim for financial loss. That would be if they're sacked, for example, or dismissed, for example. They'd be claiming for their loss of net income from dismissal until such time as they get a new job somewhere else, when the loss stops. And on top of that, they could have a basic award for unfair dismissal. It's based on their age and length of service, same as a statutory redundancy payment. But also, in a discrimination context, they claim what's called injury to feelings, which that's the uncapped bit. And so it's how long is a piece of string, type thing. The judge has to make a decision on how long the string is. But they have some guidance. There's 3 different bands, lower, middle, and upper. I'll just grab the bands, 2 seconds. So and currently the lower band is £900 to £9,000. The middle band is £9,000 to £27,000. The upper band is £27,000 to £45,000, but there is in theory no cap. So a judge could award a lot more than that. And so it's very expensive. And then of course on top of that, tribunal fees. You're probably looking in average for discrimination claims are rarely quick matters. They're very involved, more complicated than unfair dismissal usually. Often you have it all jumbled together, several claims in one. But you could easily rack up. For an ordinary unfair dismissal claim, you're looking at easily 12 grand plus VAT in legal fees for a one day case. Obviously, the more days involved, the more barristers' fees will be involved. The more expensive it gets. So it can be very expensive.
It quickly escalates, doesn't it?
Yeah. So it really does pay to do things right the first time around. The best way to do that is have decent contract in place and decent policies and procedures in place and follow them. at least then you've done the right thing and you won't go far wrong. What tends to happen is businesses don't do that sort of thing. They don't have proper contracts in place. They never been signed or agreed. Policies are out of date or they haven't got any. And then when it comes to being sued, they're on a back foot, and trying to defend them is hard. Not impossible, but more difficult. And so it just makes more sense to do that. You see the headlines in the various papers about these massive awards. Often it's because the employee is very highly paid to start with, so the loss of earnings is very high. But equally on discrimination claims, where there's been a long campaign of harassment, for example, it's going to be a very high payout, because the effect on the individual, how it's affected them, will be considerably greater than if it was a one-off act of harassment, for example. So it all depends on the severity, and it's the impact on the victim which matters. It doesn't matter what the intention was. Really, it's if the person feels that their dignity is being violated, then that's enough from a harassment point of view.
Okay, yeah. That does drive home the point that how important it is, isn't it? Yeah. Now, one question that I know has come in from pastors, and in terms of equal opportunities and trying to balance what the biblical principles are of employing, say, a pastor into a role where you've got a biblical requirement of what that should look like in a job description, and you then got the legal requirements, and so is there a way to bring those two together? So the churches want to protect that they've got a pastor who loves Jesus, who's following a code of conduct, who's following a statement of faith. Are you able to write those things into contracts, into staff handbooks, from that kind of biblical perspective, as well as meeting the kind of legal requirements?
Yeah, where it gets more complicated here, because we're dealing with religion and belief. I mean, there is a religion and belief is a protected characteristic. So Christians are entitled to be protected, as well as Muslims and other faiths, and those who have no faith at all, atheists, etc. So philosophical beliefs are also covered. What's important is that whatever you're doing, you're complying with the law. So as a pastor, yes, where they're required to teach biblical principles, the contract will look slightly different to where there is no teaching requirement and there is no requirement that they believe certain things. There is no. It will depend on the nature. For example, the contract for an office cleaner will be very different to the contract for the pastor. Because there are different obligations. The cleaner isn't going to teach anybody anything. You wouldn't strictly need. You wouldn't need to have necessarily a Christian cleaning the church
in that role.
Whereas you would need a Christian preaching from the pulpit. So there's a difference. So it depends on the scenario, and you are allowed to make variations like that in strict circumstances. So the care needs to be taken when drafting contracts, which is why I go back to what I said before. That there isn't one size fits all. You can't just flick something from the internet and use it for everybody. You need to tailor the contracts to the individuals involved.
Yeah, that's great. And you can offer that advice to people as they work through those things as churches, particularly because they are going to want to have those distinctives, and holding pastors to those statements of faith, is important, and where they deviate from them, lots of churches, where someone's teaching something, that isn't considered to be biblical. How do, organizations like churches, trustees, take action to bring somebody back in line, or maybe have to dismiss a pastor who has deviated from everything that they've ever believed, and we do see some of that in churches, and that does happen, and how do organizations protect against that as well?
Well, I think one important step will be to have a clear constitution for the church, what you agree, what your beliefs are, and tie that in when recruiting for example, a minister, pastor, and so everyone's clear on what the articles of faith are believed, and that sort of thing. But as I said, that'd be very different and the obligations that you would introduce in a contract for a pastor would be extremely different, totally different to somebody who hasn't got any teaching responsibilities, like the office cleaner, the church cleaner. It would be different. So you need to sort of can't really sort of cover it all in one podcast because it's quite a complicated topic. But you can do it. Just need to take care when tailoring the contract.
Yeah, and I think for church administrators like me and other churches, you are dealing with both sides. You're building maintenance staff, and then you've got the kind of ministry side, which again is slightly different. James, thank you for your time today, mate. I love your expertise, and you've got a whole host of experience that we can sort of lean on as churches and administrators, and the church office. The opportunity to put this together really does serve churches, and to begin to start those conversations in their organisations, and then to be able to to think about, right, what are the 9 essential policies that you've referenced, and we can put those on the website and make those available. And where people want to, explore those conversations further with yourself or with the church office, and that we're willing and desirous to help people to get these things right and to serve, our employees, and also to protect our organisation and the gospel ultimately. So, James, thank you, mate, for your time.
Pleasure. Thanks a lot. Thanks, Gavin.
Great.